Zoewebs sharing today. What is cyber law? Do you think we have cyber law in Malaysia? The answer is no. Actually, we do not have specific cyber law that governs activities online. We do not have a specific act that lays down all the regulations and the legal requirements. So what are the common statutes or the common law that govern internet activities? So these three are the most common one. First one is the Computer Crimes Act. It relates to computer crimes like hacking, phishing, cracking and virus attacks. Second one would be the Communications and Multimedia Act. This one relates to content. For example, it would prohibit you posting contents that is offensive or like porns, like pornologies is prohibited in Malaysia. All these activities are governed under this act. And the third one, which is the one law that we're going to discuss today, is the intellectual property law. So what is intellectual property law? Which is patent, trademark, copyright, and so forth lah. So the topic that I'm going to present today is two major legal issues surrounding the website that you should know. So what are these two legal issues? Okay, what will we cover today? The first issue is domain names and how it relates to trademark. The second one will be how we're going to protect our content by using copyright law. Two major issues. First subtopic, domain names. How to protect it and what is the applicable law if there is a dispute. Before we go into that, what kind of law that goes to protect domain name, let us recap some basic knowledge about domain name because we have new members here. So how to acquire a domain name? Basically, there are two options. Either we register a new one or we purchase an existing one. So what should you be aware of when you register or you purchase? Two things. Whether anyone owns the right to the domain name or whether the name is a registered trademark. Because if the name is a registered trademark, it could prevent you from using the domain name. The answer lies in trademark. So what is trademark? Trademarks is actually a unique symbol or words used to represent a business or its product. The domain name, it can be a trademark. So the protection of trademark is provided under this Trademarks Act 1976. So any infringement of such act will amount to a cause of action, meaning that you can actually bring a legal suit against the infringer. Does it apply to domain name? Yes, trademark does apply to domain name, although we don't have a specific law that provides for it. Malaysian, as well as other countries, have recognized that the protection of trademark laws extend to the use of trademark over the internet. This covers also domain names. So, in simple words, meaning that we don't have a cyber law that governs domain names disputes, but we are using intellectual property law to govern domain names. Here's a fun fact that I would like to share with you all. So, what do you think? What's the difference between the TM symbol and the R symbol? Both also relates to trademark. So, what's the difference? Why sometimes people use TM? Why sometimes people use R? TM stands for a symbol, a word, or a sign that is as an identifier of the source of the product service. So which means that it's still pending registration. So once it is registered, it becomes R. So which means that with R symbol, you have a full protection of the legal rights. But with the TM, it does give you a right, but it's not as complete as the R symbol. This is just a minor difference. So what is the legal dispute over domain name that could arise from domain names? Which is cybersquatting. You might not know what is cybersquatting. So let me explain. What is cybersquatting? Cybersquatting is from such an act. Okay, with this you might have a lot of marks above your head. So let me give you a real example. This is actually a real case, happened in 2008. Google Inc against Digiattack. Digiattack is a company that based in Ipoh. So what happened was, Digiattack registered www.google.my as its domain name. So Google filed a complaint against Digiattack. And at the end, Google won the case because it managed to prove that the domain name was identical with its trademark and was used in bad faith. So the court, it's actually not a court, it's actually an arbitration panel, held that the disputed domain name to be transferred back to Google. Which means that now Google owns www.google.my. Previously it was not because of these cybersquatting activities. So this is also an established principle that we recognize trademark law that can protect domain names. When you face legal disputes like cybersquatting, like someone using your domain name without your permission, so what should you do? If you are a trademark owner, what should you do? What are the legal options that are available to you? So basically there are two options. First, you can file a complaint. Second one, you can file a court action. For a court action, I'm not going to go into detail. You might need to consult a lawyer to explain the details to you. So what you can do as a layperson is that you can file a complaint because it's much cheaper than court action. So if the domain name involves .com, .net, .org and so forth, you can actually file a complaint with WIPO under this policy. You just Google it and then there will be the guidelines that guide you what are the requirements that you need to fulfill in order to file this complaint. So if the domain name involves .my, then you can file with my needs under this policy. All this information are actually available online. So you can actually access to this information by Google it, just Google it. What are the remedies? So after you file a complaint or after you sue someone, for sure that you want to get back something from the opposite party, right? So what are the remedies that recognized in Malaysia? 4 remedies. Transfer, injunction, damages, or accounts of profits. So what is transfer? Transfer is like the case like I showed you just now, Google against Digiattack. So the court, the judge or the panel will actually instruct the other party to transfer back the domain name to you as a legitimate owner. Injunction meaning that you can actually stop the person from using your domain name. For example, the legal proceedings is going on, but you want to stop the person from using your domain name throughout the proceedings, you can file that injunction to stop the other party immediately. If the court allows, if you're able to prove your case. And third one would be damages. Damages, which means that you can claim the loss that you have suffered from the infringer, as opposed to accounts of profits. Accounts of profits go the other way around, meaning that you can claim the profit that the infringer has gained by using your domain name. So damages and accounts of profits you cannot claim simultaneously. It's either or. Here's the end of our first subtopic, domain names and trademarks. So this is a summary in 2 points. What are the key takeaways that you have to remember? First one is registration does not equal to legal right. So you register a domain name doesn't mean that you own the interest or right of the domain name. So a domain name can be transferred from the registrant to the complainant if the complainant able to prove a case, like the Google against Digiattack case. So Google able to prove that I have the interest, I have the legitimate interest in the domain name, in the trademark name, so I can instruct you to transfer back the domain name. Second one, how to prove? How to prove that you have the legitimate interest in a particular domain name? You can 2 elements. First one would be the name must be either identical or very similar to your domain name. Like google.com.my is basically identical to Google. The second element you need to prove is that this domain name is used or registered in bad faith. For sure that you know, a lot of people actually they buy the domain names of like Nikes or those famous brands so that they can resell these domain names to the other party to gain profit. So this kind of activities is considered as bad faith.